In their own reports, they say they demolished some churches and whatever, and garages and whatever. Now, even that particular thing, even if those things were on public land, the ones that they demolished, there's no evidence of proper compliance with the law when they were evicting those people and whatever they did. At Roman 13, I look at aviation safety. And in my further affidavits, I produced expert studies by Kenyatta University lecturers who have studied that area in terms of aviation and town planning. And the study concluded that from the findings of the study, it can be concluded that land use changes is a major threat to the safety and security of the Wilson Airport. This is evidenced by setting up of major shopping malls near the airport, proximity of Uhuru Gardens to the airport, adjacent Nairobi National Park, multimedia Mitumba slums, and upcoming high-rise developments. And if you the question of the high-rise development, you'll find that even what was allowed by the civil aviation is not what is being implemented, because if you look at the building that are putting up in that area, if you look at in terms of meters that have been given, you are talking of a building like Rahimitullah Tower out here. So those are very huge buildings that are going to be erected on that fly path, and I've shown the calculations here in my submissions that show that it is not viable to have those structures constructed in that place. I've also shown that the EIA license they're relying upon is also a forgery. They've given an EIA license using a manual system that they no longer use. The manual system went out of use a long time ago. They're using a digital system. And if you go to the digital system and try to look for that license, it doesn't exist. So these are among the issues that it is problematic. And that license, issued after the event, even violates at Section 58 of the MCA. So I've also detailed the constitutional violations. I've looked at Article 10. I've laid out how Article 10 was violated. Article 42, 43, 47, 227, 62 and 66 on public land and its use. Then there's been the question of structural relief. And I'm also trying to argue that this particular case does not allow, the respondents cannot get a structural relief that they're trying to pray for in some of their pleadings. Whereby my understanding of a structural interdict is that it's a remedy where a court, instead of striking down an unconstitutional act or halting an illegal project, supervises the relevant authority to take corrective measures within a specified time frame. So, and I've shown that that kind of remedy is available within certain minimums, still within certain minimum provisions. In this particular case, the violations are so substantive that a structural interdict cannot issue in favor of the respondents.
Yes, wind up, Mr.
Yes, my lord. So the respondents have acted have not acted in the public interest. Have acted in bad faith. And I pray that the petition be allowed as prayed. And especially you look at the final part, I've highlighted the admissions of material facts that are fatal to their case. I've also documented them in my submissions. So basically, I also argue that some of these documents constitute a fraud on the court that should not be taken kindly. And in conclusion, I say, my Lord, this is not a case of minor procedural irregularities that can be cured by conditional orders. It's a case of fundamental, deliberate, and pervasive violations of the Constitution and statutory law. The respondents commenced construction without a license. They fabricated public participation records. They procured a consultant unlawfully. They issued a license in defiance of court orders. They fabricated evidence to deceive the Honorable Court. The only remedy proportionate to these violations is to grant the final orders prayed for. And I also plead that to issue a structural interdict in this case would be to reward bad faith, to condone the fabrication of evidence, and to send a message that public authorities may ignore the Constitution with impunity. This is not the law. It's not the public interest. It's not the justice that this court is sworn to uphold. And therefore, my Lord, I pray that you allow the petition, grant us the declarations, and grant us the final orders. That's all, my Lord. I thank you for your time.
Thank you, Senator.
And let the court. And my Lord, I would invite the court to look at the affidavit of Mr. Mumo from NEMA, dated 29th December 2025. That is paragraphs 29th, it's dated 29th December 2025. I would like you to look at paragraph 6 to 10. That's where they depend on the question of the license. And I would ask the court to hold that what NEMA depends against the regulations of how a license is issued. The license number NEMA/EIA/PSL/0001-425 of 16th December 2025 it was issued irregular and did not follow the laid down procedures. The deponent in those paragraphs refers only to a project report as the basis for that license. Does not refer to a full ESIA study report, which is mandatory for projects of this kind, which are listed in Schedule 2 as high impact projects. The process of issuing this license bypassed, there's no scoping. The TORs for the project were not approved. The baseline studies were not done. Alternative analysis is not presented. Mandatory public participation under regulations 11 to 23 is also not presented, if you look at that paragraph. And as for the license itself, if you go to the NVIS, my lords and my lady, on 28th July 2025, NEMA migrated to a digital system. And the system, the URL for the system is https://licensing.nema.go.ke.
On which date?
28th of July 2025. That's when the system came up, and NEMA migrated from manual licenses to digital licenses. I invite this court to go and visit that site, enter that NEMA number, and see what comes out. Enter the license number. The application reference number is NEMA/ENVIS/SR/009. you'll find there's no record of that license. Enter the license number, you'll find there's no record of that license. So basically, that's why I say that that license is a forgery, does not exist. And that's just what I would say about the license. As for the claim by Mr. Alan Kamau that there's no evidence of surrender, I would advise, this is a court of record, my lord, and the interested party, the project affected persons, produced 2 judgments in the affidavit making specific findings. At page 2 of the affidavit of Fred Muriungi, there's the case of Waitira versus Kena, where the court finds that there is a 30-meter buffer zone surrendered by the residents. My lord, at page 85 of the interested parties affidavit, the case of Kisumu Guest House versus Ouma, it also confirms surrender by the Southlands Housing Development Corporation for public use by the residents. On public participation, my lords and my lady.
Before we move to the issue of public participation, yes. You want us to look at the judgment to make a finding that indeed there was
no, the judgment made a finding that there was surrender. In that code, the issue has been litigated before.
So you want us to look at that finding and make and agree that where these houses are being built was actually a piece of land which was surrendered?
Yes, my lord.
Okay.
Because there is a court of record. On public participation, my lord, there was a long list produced of residents from Southlands, civil servants, Rubia, Ngei, Moi, Sun Valley, Camp David, Royal Park, who are demanding, and also wrote letters complaining about public participation. They all contend there was no public participation, and the burden of proof was on the government to prove that there was public participation. And in the case whereby, my lord, the High Court invalidated, I don't get I can't do the citation, but I know what the case is about. The case in which Justice Chacha Mwita, then as he was, invalidated the Contempt of Court Act. It was clearly stated that where an allegation is made that public participation was not held, the burden shifts to the duty bearer to prove that there was public participation. The duty bearer in this case has not discharged that burden. And my lords, you have been told that procurement cannot be addressed in this court. I think it is trite now, and it's a common position that if a constitutional matter arises as an auxiliary issue during a matter which this court has jurisdiction over, this court will entertain that plea and will address it. Somebody has been brought here as an expert witness who is hired using public money. I have the right to question how that person got to work for government. Was he procured according to the law? So this court has got full jurisdiction to address any issues that arise from this case that touch on Article 227 and on the Public Procurement and Asset Disposal Act. You have been told that the Act, the Affordable Housing Act, was subjected to intensive public participation before it was passed. But my lord, that was on the legislative side of issues. It does not automatically transmit to the executive side. When you execute projects under that act, you must hold public participation for each act, for each development. So they cannot rely on the public participation that was used to approve the act to claim that it has approved each and every project that will be done under that act. It approves none. Article 43, my lord, you have been pleaded in reference to Article 20, Clause 5. Article 20, Clause 5 is very clear in its wording. It only says that where the state says it has got no money or no resources to effect something, the court will not compel it. But all at the same, Article 43 is not the entire Constitution of Kenya. It must be read in the context of the entire Constitution. It can only gain meaning when the Constitution is read as a whole. It cannot be pursued as an isolated issue. You have been told that the prayers open themselves to a structural interdict. My lord, this case has developed. Under Article 23, this court has got the power to give appropriate reliefs, and the case has developed. When the petition was filed, the evidence before this court that has been produced by the respondents was not there. Now, the evidence that has been produced by the respondents condemned them even beyond where the petition had reached. And on the basis of that, this court, and in my submissions, I've pleaded that this court should provide appropriate reliefs beyond and over what was prayed for in the petition. Because when I filed the petition, I did not know how deep the rot went. But when they filed their responses, they exposed everything. The board cannot come here and ask for a bowl of water to wash their hands like Pilate. The board has got supervisory role over these provisions. Approving a budget, when you are given the power to approve a budget, you don't just throw money at anything. You must go down and convince yourself that what is being done is proper. And my lord, I would invite the court to look at Article 229, Clause 6 of the Constitution, and look at what does the Auditor General look for when they audit a project. We are told in that article, 229, Clause 6, that a report of the Auditor General shall demonstrate whether public funds were used lawfully and effectively. So the board has a mandate and a duty to ensure that whatever the money it is giving out is going for a lawful purpose. You cannot just give out money without going further to ensure that there's a lawful purpose it's financing. The eighth respondent has claimed it has got no business. It's a bystander. It's not a bystander. The eighth respondent has the duty to do planning in this city. It has the duty to ensure proper land use, and it approves any development. Their admission here that they did not discharge that function is enough to stop this project.
But that was not one of the issues.
It was not one of it. It's an issue that has emerged. A structural interdict. There should be no structural interdict in this matter.
If you are sitting where we are sitting, how would you frame your relief, the appropriate relief? Which appropriate relief do you have in mind?
The relief I have in mind basically is just that the project is permanently a permanent injunction against the project.
Forever?
Yeah, it cannot be done.
Okay, thank you.
Thank you, my lord.